Okay, we're back on the record. This is the time set for sentencing in this matter. Ms. Klages was found guilty by a jury of lying to a peace officer, 2 counts. One of them is a felony punishable by up to 4 years in prison. The other, a misdemeanor punishable by up to 2 years in prison. And before I go any further, I just want to go over a few little ground rules. First of all, as I've already indicated, one of the victims does not want to be photographed. I'll ask the prosecutor to please let us know as she is getting ready to speak so that we can make sure that I change the camera as well. And it's really difficult throughout the proceeding to perform my role as judge and to be the social distancing police at the same time. So let me just tell you at the outset, per the Supreme Court guidelines and the rules here in this building, everybody has to wear a face mask unless you're currently speaking. If you are currently in a speaking role, you may remove your face mask. Even with a mask, everyone who can must remain 6 feet apart from others. If you're a member of the same household, you don't have to be 6 feet apart. If you need to communicate with someone during the hearing, like attorneys with each other, attorneys with client, support persons with those they're here for, you don't have to be 6 feet apart, but you do have to wear a mask. And then everyone will speak from the podium in order to just keep the social distancing going the best we can, and also in order for me to change the camera to only capture the person speaking so that we don't run into a problem with the one victim that doesn't want to be photographed. And as I've already indicated, the hearing's being live streamed, so it may be as open to the public as possible, and also to accommodate some media requests to watch and record remotely, which was better than the alternative of having everyone come down here. Second, or maybe not second, but I'm not necessarily saying that I expect anyone to do this, but just to be clear, this is a court proceeding. We have rules of courtroom decorum. There's no clapping, yelling, whistling, booing, or other verbal or nonverbal expressions allowed. So I think those are pretty much the basic ground rules, and we previously had an off-the-record discussion just to discuss the logistics of proceeding to a sentencing during a pandemic, and it became clear when discussing those issues that we were talking about who would be present at the sentencing, and it became clear that prosecution and defense had a difference of opinion on who would be considered a victim under the Victim Rights Act and thus be allowed to speak today. I asked for briefs to be submitted, and that was done. I told the attorneys I told the attorneys what my decision was after I read the briefs, because I wanted everyone to be able to plan accordingly. That decision was that RF and Ms. Boyce do meet the definition of victim under the Victims' Rights Act, and they will be allowed to speak. And just for purposes of making a complete record, I've made that decision based on the Crime Victims' Rights Act, and specifically MCL 780.752(1)M. And that section defines a victim as an individual who suffers direct or threatened physical, financial, or emotional harm as a result of the commission of a crime. And I specifically find that RF and Ms. Boyce suffered direct or threatened emotional harm as a result of the commission of the crime of lying to a police officer. Just to expand a little bit, my reasoning is as follows. When the police interviewed the defendant in 2018, she could have either corroborated Ms. Boyce and RF, and said that they did report sexual assaults to her, or she could have denied that they ever reported anything to her. She chose the latter, and by doing so, she contradicted Ms. Boyce and RF. And that's fine in and of itself, but the jury found that she intentionally lied when she did that. That intentional lie was in the highest of high-profile cases. Essentially, it at the same time called out Ms. Boyce and RF as either liars themselves or persons with completely fanciful memories. Having observed RF and Ms. Boyce, and having heard their testimony, it's evident that the lie that the jury found caused emotional harm to RF and Ms. Boyce. I am not relying on the fact that they were trial witnesses and subject to cross-examination, although that gives me comfort as far as due process goes, because the defense had a full and fair opportunity to cross-examine them. But I'm not relying on that to allow them to speak as victims. Their veracity was questioned at trial, and that's something that happens in every trial. It's an absolutely necessary part of every trial, and so that is not the basis of my ruling. It's what happened outside of trial, that Kathy Klages painted them as liars when she told the police in 2018 that if they had reported, she certainly would have remembered, and that, in my view, makes them victims under the Crime Victims' Rights Act. So there's that issue, and then also prior to sentencing, I received a motion and brief from the defense to strike the letters that I received. I received about 17 letters, thereabouts, from the Attorney General's office.
I believe it was, in addition to Ms. Boyce and Ms. Fountain, 24 letters, 5 of whom were from Ms. Boyce's family members, and the other 19 were from other individuals, 17 of whom had never met Mrs. Klages.
Okay. And about 100 letters submitted on behalf of the defendant. So did you want to argue that, Ms. Chartier, the motion to strike the letters?
I believe that we've put our arguments in the brief. If the court would like to make its ruling, or if the court has any questions for me, I'm happy to answer them.
I don't. Thank you very much. So, you know, I have reviewed the letters prior to you even filing a motion to strike the letters. I am not going to strike the letters. I'm just not going to squelch the public's ability to speak out and express their opinion about high-profile sentencing, or any sentencing for that matter, and I never have, and this is not the first time this has happened. I get letters that don't go through the prosecutor sometimes on cases from the public, having an opinion about a case that I'm going to sentence on. I wouldn't strike those and squelch the public's voice any more than I would strike the letters on behalf of Ms. Klages, because if that's the theory we're going on, that they have matters in them irrelevant to sentencing, then with all due respect, while I appreciate the letters and I consider them, I would not be able to consider the fact that Ms. Klages is loved by her family, is loved by her friends, etc., etc. That's information that I'm not denigrating, I'm not discounting, but it's no more relevant to the factors that a judge uses for sentencing than the argument about the letters that I received through the Attorney General. So, and also I would add that almost 16 years on the bench, I hope by now I've at least demonstrated that I know how to sentence people in a fair and just way based on only the factors that are legally relevant, and I don't think that that means that I cannot read a letter that contains extraneous information or additional information. So I am denying the motion to strike. And then Ms. Chartier, have you had a chance then to go through the pre-sentence report with your client?
I have, Your Honor.
And as far as just the report itself, I'll get to the guidelines, but the report itself, did you have any additions, deletions, or corrections?
There are some corrections, Your Honor.
All right.
And would the court like me to remain here or come to the podium?
I'd like you to speak at the podium.
Okay, thank you.
And you can remove your mask once you get to the podium.
I'm sorry, beg your pardon, Your Honor?
You can remove your mask when you're speaking at the podium.
With all due respect, Your Honor, if I may keep it on, I would like to do that just for health issues, but if the court can't hear me, I certainly can remove it.
No, I'm not making anyone take off their mask.
Thank you, and I have such a loud voice, no one's ever said that they can't hear me, so. On page 1 of the pre-sentence investigation report, under personal history, It says substance abuse history, yes. We believe that should be no. The reason being is for marijuana usage, for Mrs. Klages, it was from 1972 to 1977, essentially when she was in college. And she used approximately maybe 2 to 3 times a month. Then in 2018, she used approximately twice during that time.
Okay, so then I assume that means you're going to correct the information later on in the report?
Yes, but I just wanted to provide the basis for why I believe that should be no.
Understood. If there's no objection, I'll change that to no.
And then the years on the first page would be 1972 to 1977.
Okay, I've made those corrections.
Under evaluation and plan, on the second paragraph, Mrs. Klages' age is 65. It lists it at her as 64.
Got it?
There are portions under evaluation and plan which are the pre-sentence report writer's opinion, which we don't believe should be in the report, under People versus Grable and under People versus Frisky, because they're the subjective opinion about Mrs. Klages. I can highlight what those are for the court. It would be in the 4th paragraph, the 2nd sentence that starts the defendant not. It would be the next paragraph, the 5th paragraph in its entirety. In the next paragraph, it would be the first 2 sentences and the second to last sentence.
Do the people have any position?
Yes, Judge, if I can respond. As to the age, obviously, we have no problem with that. I make no comment as to the first 2 items that Ms. Chartier has listed. Going to the last paragraph on page,
I think they're unnumbered.
the evaluation plan, last paragraph. The defendant has continued to minimize her role in the destruction of the victim's lives. That's not really opinion.
Well, she's entitled to maintain her innocence.
I agree with that.
And if they call that minimizing, I disagree. That's,
Okay, very well.
I'm striking that. I'm striking the 1, 2, 3, 4, 5th paragraph. And I'm striking what was the first paragraph of the first sentence of the last?
The first 2 sentences of the last paragraph and then the second to last sentence.
Yeah, I got that one. Those are stricken.
Thank you, Your Honor. The next page has a guidelines issue, but I know we're going to be talking about that later.
Yes.
On page 6, under adult history, it indicates that the conviction date and method was by plea, and that should be changed to a jury trial conviction.
Got it.
On page 7, it indicates that Mrs. Klages is the 4th of 5 children. It says 4 of 5, it's actually 4 of 6, and that's the first full paragraph under family.
She was 5.
It says she was
Of
4
6.
of 5.
And she was 5 of 6.
She was 4 of 6.
Sorry.
Sorry.
Got it.
On the next page, page 8, under employment, it lists her as having been the, she was 3rd of 6, not 4 of 6.
Okay, hold on. I'll never figure this out. She was 3 of 6. Got it.
On the next page under employment, it lists that Mrs. Klages was deputy athletic director. She never held that position. She was the head gymnastics coach.
I've made that correction.
Under education, the one sentence underneath the box says she graduated from Springport High School. It should be Spring Lake High School.
Got it?
For substance use, for THC, the start date should be 1972, and the end date should be 1977, which would make the age of first use 18. She indicated the best she can recall, it would have been 2 or 3 times a month.
Okay, I think occasional.
Okay, sure, thank you. And then for alcohol, the start date would be 1970. And then the age of first use would be 16.
Got it?
Under health, she's been diagnosed with a heart murmur that is being monitored.
That's not on here at all, right?
No, it's not on there at all. She doesn't take any medication for it.
I'll just add she is being monitored for a heart murmur. Okay.
On the next page under finances, it has an other bank account of $76,147. Mrs. Klages said she doesn't know where that bank account comes from. That should be deleted. That's not something she's aware of.
Got it?
On the basic information report, under current offense for number 1, it has victim relationship. Consistent with our previous objection, we just indicate that the 2 individuals should not be listed as victims. I understand the court's already made its ruling. I just want to be consistent with what we've already stated. And as it relates to modifications to the report, those are the only items.
Okay, did the people have any corrections to the report?
No additions, corrections, or deletions, Judge, no, thank you.
Okay, then let me just address guidelines. So it looks to me that the prosecution and the defense actually agree that OV4, OV9, and OV10 should be changed to 0 based on the briefing.
Yes, Your Honor.
Yes, Your Honor.
And so I've changed that. There was disagreement over OV19 that was addressed in the defendant's sentencing memorandum. Did you want to address that, Ms. Chartier, or add?
No, we put everything in the sentencing memorandum, including that we are offering up more than just a denial of interfering or administering or with the administration of justice. The other point that I don't believe was made in the sentencing memorandum clearly, but I want to make sure is Mrs. Klages went to a therapist in 2017, long before she had a conversation with Agents Dwyer and Sklobasi, long before she was charged, and talked to the therapist about not remembering this conversation. So we're trying to put forth evidence that she did not interfere or attempt to interfere with the administration of justice. We did that by including the 2 reports from the polygraph operators, as well as discussing with you the therapist that she saw in 2017. Thank you, Your Honor.
Did the people wish to respond to the OV19 objection?
If the court doesn't have any questions, I don't have anything other to add other than our pleading and also People versus Harvey.
Right, I'm going by the verdict of the jury and nothing else, and I think OV19, despite all of the arguments that she didn't lie and didn't remember, the jury found otherwise, and OV19 is properly scored at 10 points. So are there any other objections from either side about scoring?
No, I believe that changes the guidelines to 0 to 17.
Yes, so just for the record then, the guideline range is where the prior record variable score is at level C. The offense variables are at level 2, which is a total of 10 points. And the advisory guideline range is 0 to 17 months. And
that does change the body of the report on page 2 underneath all the compass information. It says the Michigan sentencing guidelines range is 2 to 17 months. It would be 0 to 17.
It's going to change the BIR as well. Yeah, the BIR down at the lower left should also be 0 to 17. Got that?
Yes.
Yeah, okay.
Yep. Thank you, Your Honor.
Thank you. And next step is, thank you, Ms. Chartier.
Thank you.
Are there victims now who wish to be heard?
There are, Your Honor. Gonna have RF approach first, if that's okay, Judge?
Sure, let me just change the camera here. Got it. All right, this is RF, so this individual does not want to be photographed.
Can we take audio still?
Yes. Go ahead, whenever you're ready. Take your time, it's all right.
Dear Judge Draganchuk, I want to thank you for making the decision, even after much opposition, to give Larissa and I the opportunity to share our hearts and minds with our impact statements today. You have given us a voice again by being able to publicly tell the truth and the effects it has had on us, our families, and our sister survivors. Although this whole process has been horrific and very hard on us, knowing that we took the proper steps and went through a fair trial, and the defendant was found guilty by 12 strangers, is a small victory in a world where harm is done and the innocent not always defended. When I was called into her office when I was only 14 years old, I knew that what I was about to tell her would be shocking and news that she would immediately share with my father that night. I felt scared of this conversation that we were about to have, but I also felt a huge sense of relief that she would speak up for me. For I was too young, too nervous, but she was an adult and a strong woman that I looked up to and trusted. But the opposite happened that night. What she did with my information couldn't have gone worse. She questioned me like I was already in trouble, and instead of offering me advice or protection, I was offered a cold and harsh answer. We aren't going to talk about this anymore. That answer caused devastation on my entire life, physically, emotionally, mentally, and financially. I left gymnastics that evening feeling more trapped in an abusive situation. The first and only adult I had ever told just canceled all of my intuitions that sexual abuse is real and painful and wrong. She silenced me not only when I was 14 years old, but for another 20 years, I did not have the confidence to speak up about it again. A simple decision on the part of an adult female in a position to use her leadership and authority to protect and defend young girls turned into a detrimental effect on hundreds of girls, women and their families, spouses, their children, a ripple effect over the course of 2 generations. It is very simple and very straightforward. In that instant, she should have given us the opportunity that any adult who was a coach and a mother would do, to listen and to protect. She should have acted instantly and acted with intent and purpose and immediately told our parents and the police. Her choice to protect herself and Nassar has hurt myself and so many others. My sister survivors said being able to share with the judge today what happened to them would offer some sort of healing and closure. They asked themselves, what if Coach Klages would have done the right thing in 1997 and contacted the police when Larissa and Rivka came to her and told her about the abuse? What if Larry Nassar was stopped in his pedophile tracks by one adult friend who believed the cries of 2 young girls? Here is in their own words. I'll read a few now to help you understand. Jane Doe number 1. I would have never been one of Larry's patients. I was only 6 years old that year, and I was not treated by him until 2001. Jane Doe number 2. I would have never experienced sexual trauma. I wouldn't have had to watch my parents' marriage crumble before my eyes. I wouldn't have ever questioned my self-worth or intuition, and I wouldn't be disgusted with being an MSU alumni today. Jane Doe number 3. I would have actually seen a doctor that could have helped me instead of hurt me. I wouldn't have had such horrible nightmares and depression that I overdosed on pain medicine. Jane Doe number 4, I would have never been abused, and I wouldn't still be struggling with PTSD and health issues that keep me from working. Jane Doe number 5, I would have never had daily anxiety attacks, and I would have never gone into stress-induced labor and delivered my daughter 5 weeks early due to the emotional and physical trauma I endured. Jane Doe number 6, I would have never gone to see Nassar when I was 12 years old for my gymnastics injuries and been abused by him for 5 more years. Jane Doe number 7, I would have never had to explain to my parents what happened and be asked on a regular basis by strangers, are you one of those girls? And lastly, Jane Doe number 8, I would never have become a victim, and if Kathy would have told the truth to police when I first reported in 2016, I would not have been left alone, mocked on an international platform, with a chain of evidence to other survivors cut off at the point that it mattered most. There are so many more, but I can't read them all today. On behalf of all the sister survivors, they say thank you for letting them be heard today. In validating their suffering, they also will begin to move forward on their healing journey because of the actions that you take today. In February of 2017, I finally gained the courage to tell Andrea Munford and the MSU Police Department what the defendant should have told them so many years ago. About a year later, I was called into an office and met a few prosecutors from the Attorney General's office. They asked me if I would be willing to testify about what happened to me when I spoke to the defendant in her office. To say that I was scared or nervous is a huge understatement. It went against every comfort in my life to carry through with this so many years later. I didn't want anything more than to just stay quiet and try to heal at this point. I was worn out beyond comprehension, but my compass is strong, and I knew I needed to once again speak the truth and let the law take over the situation that weighed more heavy on me. The defendant had the opportunity to make a decision when I was only 14. She was presented with concrete information about sexual abuse, and she made the wrong decision in that moment. She had the obligation and the opportunity to speak up, but instead she chose to do what was more convenient to herself and her friend Larry Nassar. She also made the same exact awful mistake on June 21st of 2018, years later while being questioned about what she knew by Detective Dwyer. A decision that brought Larissa and I back to the very same pain and trauma that we had to relive in countless meetings with people we didn't know and share very detailed information about our lives and relive the trauma over and over again, going through this legal system and publicly speaking. My hope was that she would be sorry and deeply apologize, but that is not the case. If she was sorry, she would have reached out to us and sincerely apologized. If she was sorry, she wouldn't have lied. If she was sorry, she wouldn't have dragged us through all of this again. If she was sorry, she never would have had an attorney who maliciously tried to show that we were lying or not credible. Shame on her and her team of attorneys for defending her at Michigan State University. You saw 2 women come forward to testify at trial. You tried to take our information and distort it, twist it, and falsify it. You scraped and pried at any personal facts about our life to try to scare us, attack us, and defeat us for telling the truth. All to try to win a case that was based on lies. You tried to use the legal system in a backwards way to prove your point, but thankfully you failed and the jury saw right through you. I am so disappointed in your tactics to defend a person and a university that enabled a predator and that still will not own up to their mistakes and instead tries to hide and deny responsibility of all the evil that was done to hundreds of girls, all so that you could try to win a case and win a profit. I am so grateful for a fair trial, and that you, Your Honor, had the wisdom to discern and judge what is true and veritable. Judge Draganchuk, I do not believe at this point that the defendant can be rehabbed. She is not remorseful, and she has not admitted that she caused harm and that what she did was wrong. She is blatantly denying any wrongdoing on her part all the way through. She not only disregarded us, but she used her position of authority in a harmful way by enabling him in the worst way for years and years to continue to practice abuse and sexual assault. She had the opportunity many times, even more recently, to help and try to reverse any wrongdoings, but instead she has done everything in her power to defend herself over and over again. Ephesians 6:13 says, "Therefore take up the whole armor of God, that you may be able to withstand any evil that comes your way. And having done all to stand firm, stand therefore, having fastened on the belt of truth and the breastplate of righteousness." If even just one adult that is presented with a similar situation someday remembers us here and what consequences followed and makes the decision to do the right thing and protect children at all costs, this is all worth it. They will remember what happened to the coach that enabled Larry, and that a jury of 12 strangers found her guilty after a week-long trial. They will remember how many lives it affected, and they will be careful and vigilant to report each and every abusive incident quickly and aggressively. They will realize that every option that we are presented with has impact on others. We should always be thinking of children and acting to defend and protect, no matter what the personal, financial, or career cost it has on us. God has a purpose for everything, even the things in our life that break our heart and take our breath away. Please exercise the full penalty and cost that you believe is needed for this situation. Thank you.
Thank you. And Ms. Joyce wished to be heard as well?
Honorable Judge Draganchuk, thank you for allowing me to speak today. My heart hurts knowing why we are here. I truly looked up to Kathy and wanted to impress her with every ounce of my being as a young 16-year-old gymnast. My dream was to be on the MSU gymnastics team. I was told by Kathy that if I continued to work hard, I had a chance to make the team, so that became a goal. During her trial, there were many hurtful and untruthful statements from witnesses, including Kathy, regarding our skill level at the gym. But if a gymnast is taught anything, it is how to have tough skin. I know the truth, they know the truth, and most importantly, God knows the truth. In order for me to move on, I am now releasing it all into His hands and His judgment. I truly had prayed and hoped that Kathy would own up to and admit her mistake of believing a pedophile instead of 2 children 23 years ago. But that did not happen. She had every opportunity to tell the truth time and again, especially in the last 4 years, to support the girls and women who had come forward, but she chose not to. She could have taken her knowledge and mistake to use it to teach the country and the world to always believe children when they disclose sexual assault. Instead, she continued to be deceitful, trying to protect herself and paint the picture that the other gymnasts and I were liars. She even went as far as lying to police and investigators in an attempt to protect her image. During the trial, Kathy and her counsel attempted to destroy our character and integrity. They tried to rip us to shreds only because we were doing the uncomfortable but right thing to do. A person is not simply granted integrity. It results from the relentless pursuit of honesty at all times. The other beautiful, brave gymnast and I were once again telling the truth, having to relive our trauma of sexual assault as well as not being believed. I was taught by my parents to always be truthful, no matter what the cost would be to myself. I can tell you that this has cost my family and I an indescribable amount of pain, loss, experiences, and time creating memories together with my family. I testified because the Michigan Attorney General's office asked me to, because even though it was the most difficult thing I've ever had to do, it was the right thing to do. Positive changes in our world will never happen unless we face the uncomfortable. Regardless of the sacrifice, I wanted to be an example for my children and other survivors of sexual assault. Thankfully, I can sleep at night knowing I was able to face my giants, do the right thing, and stand in truth. I pray that someday Kathy will be able to do the same. I believe that no matter what, God holds us in His hands. Through our struggles, trials, and challenges, there's a purpose for all of it. Sometimes it's difficult to see the bigger picture, but I know in the depths of my soul that this was worth the pain experienced during this process. I'm standing here representing my 16-year-old self, who was silenced and humiliated 23 years ago, and unfortunately, all of the hundreds of girls that were abused after me, many who were not even born yet. The abuse could have been stopped back in 1997. At the very least, my parents should have been told about it. In 1997, when I spoke with Kathy about my concerns regarding Nassar's treatments, she had the opportunity to address it, but chose to humiliate me, silence me, and protect a pedophile. When she was interviewed by investigators, Kathy had the opportunity, once again, to protect women and children and tell the truth about what she knew, but she chose to lie. When she was on the stand during her trial, again, she had the opportunity to tell the truth, but chose to lie. I lost so many pieces of myself throughout this horrible process, but slowly I am trying to put the pieces back together and find myself again. I know I will never be able to recover the time that I've lost with my family and friends, though I know moving forward that I will be able to live my life to the fullest, moving on from this hell that I've had to live in. I ask that you give the fullest sentence available, not on my behalf, but for the hundreds of girls and women that were abused after me. They never should have had to experience the same pain that I had to survive through. I ask for your justice today. Justice for the girls who were not even born yet in 1997. Justice for the girls and women who thought they were crazy for thinking that what was happening to them was sexual, but too afraid of what would happen if they said anything about it. Justice for the parents, siblings, spouses, and children that have been affected by Kathy's decision to protect her friend, a pedophile, over children. Justice because she had every opportunity to tell the truth, but over and over again chose not to. Justice because it is the right thing to do. Thank you.
Thank you. Did the people wish to be heard?
Yes, Madam.
I was in the room when Ms. Joyce and RF were asked if they wanted to testify. Obviously, we did not compel them to do so. We sought their permission. And the reason I kind of start off with this point is they made a decision then. They did. I mean, there we were, 19 years later, and they had a decision to make. And in my humble opinion, they made the right decision, and they made a courageous decision. They made a courageous decision to enter this process and undergo, the rigors of cross-exam to tell their story. And the reason, first of all, that's commendable, and the world should know that their bravery is appreciated and respected. Both messages from RF and Ms. Boyce are consistent, and that is really what Ms. Hageman Clark so eloquently pointed out in her opening statement. The truth matters. And also in her opening statement, Ms. Hageman Clark pointed out that it's not always easy to tell the truth. And as we listen to RF and Ms. Boyce today, we can see that. We can see how difficult it can be to tell the truth. The defendant had a similar moment in time, a choice, just like Ms. Boyce did, and just like RF had a choice of whether to enter this process and tell their story. She had a choice to make, and that was when she was interviewed by Special Agents Scalabasi and Dwyer. And that choice she made was to lie. It was a selfish choice, and in our sentencing memorandum, I did everything I could to point out, I believe there are two motives for that choice. One, because she wanted to protect the brand of the institution that she worked for, Michigan State University. And number two, she wanted to protect herself. Again, two very selfish motives. Backing out for a minute, institutions like Michigan State University exist, but they are only an embodiment of the people that work there, that man the institution. The institution has no spirit, has no conscience. It's a culmination of the people that attend the institution as students and also as faculty and administrators. If the world hears no other words of mine spoken today than these, so be it. But the world is now informed that Michigan State University in 1997 was aware of Larry Nassar. That much this trial has proven. The verdict of this jury proves that the head ladies gymnastics coach for Michigan State University knew in 1997 that Larry Nassar was assaulting young female athletes. I asked the court to consider how the defendant attempted to market that lie, and that's what it was. I mean, Dr. Loftus has been trotted out again in a sentencing memorandum on behalf of the defendant. Polygraph examinations, unknown how much was paid for those by Michigan State University, we don't know. But at the end of the day, the jury has spoken. And this trial, I would submit to the court, and I know the court doesn't need a lot of assistance in sentencing Ms. Klages today, and I don't mean to belabor the point, but I'll hit my points here and be done. The trial was a very simple choice. It came down to who do you believe? The testimony of the two witnesses and the story that Kathy Klages tried to market were diametrically opposed. It didn't take the jury very long to burn through that issue and reach its verdict. And a verdict that was well considered based upon the evidence that jury heard. The motive, again, for Ms. Klages was, again, to try to save herself from embarrassment and shame, and also protect Michigan State University from that same embarrassment and shame. The goal of the Attorney General's investigation into Michigan State University, and this was an investigation that was very widespread. I mean, it had over 6 Michigan State police troopers and 6 special agents from my department assigned to it, and myself and a number of other lawyers that worked on it. The goal then was to find out who knew what and when. And the lie that Kathy Klages told Special Agents Labasi and Dwyer was in direct contravention to that goal. And that goal is something that we only need to look down the road 70 miles in Ann Arbor and see what's going on with U of M there and the difficulties they're having and the same issues. To know that the goal of the investigation was an admirable one. To find out how this could happen at one of our state's largest institutions. In fact, I mean, obviously the largest educational institution, but a massive institution. How can this happen? And Kathy Klages tried to thwart that goal. It's been stated that in the sentencing memorandum on behalf of Ms. Klages that she does not need reformation or punishment. No, I disagree with that. And here's where the rubber really hits the road. She made a choice in that interview with Sklobasi and Dwyer to lie. She could have chosen a different path there. And what she could have said was, yeah, she told the truth. I do remember, and I'm sorry. I just didn't believe him. I didn't take it seriously. I neglected my duties as a Michigan State administrator, head coach, ladies gymnastics team, the head of the Spartan Youth Program. She didn't choose that path. It would have been difficult, but better than trying to thwart the truth. the truth matters, and it's not always easy to tell the truth. When she stepped up on that witness stand, I was surprised she was taking the stand. I really was. And yet, she got up there and she tried to market the same lie that she gave to Scalabasi and Dwyer. And the jury rejected it, roundly. It wasn't as if though the jury took a long time to do so. They roundly rejected her story. It doesn't make sense. It doesn't comport with our life experiences that, yeah, no, I forgot when not one, but two of my athletes told me they were being sexually assaulted by a physician, the same physician, and this all happened on the same day. No, that's not believable. It just doesn't comport with the reason and common sense and life experience. The evidence that she's not reformed is her testimony, is the fact that she wants to get up there and yes, the court is correct. She's allowed to maintain her innocence. I understand that, but the evidence of lack of reformation is found in her essentially trying to castigate Larissa Boyce and RF, telling us they're either, like you said, that they're fanciful memories or they're outright liars. No, they're not outright liars and they're not fanciful memories. They're adults now, and they told the truth, and it wasn't easy to do so. The need for reformation and the need for punishment is apparent here, and I'd offer the court. And with that in mind, we'd ask for a period of confinement. The defense spent 5 of its 11 pages in its sentencing memorandum on COVID-19, citing the New York Times, the Detroit News, the Detroit Free Press, and a number of other media outlets. And I've heard it before that the media can't be trusted always to accurately report, yet that's being offered to the court, these generalized articles. I made an email from Major Darren Southworth of the Ingham County Sheriff's Department, who is the major in charge of jail operations available to the court and counsel before the first sentencing date. And in that email from him, some salient points. First of all, obviously the systems that they have in place at the Ingham County Jail are robust, they're well organized, and they have had 0 female inmates test positive. The 5 pages in the sentencing memorandum, I would suggest, are a scare tactic to try to thwart the idea that she should have to pay a price for her lie of confinement in the jail. It is not specific. It is not directed towards what's actually going on in the Ingham County Jail. And as Major Southworth points out, the Ingham County Jail is the standard within the state of Michigan for how jails should be run with the COVID-19 crisis. She will be well cared for in the Ingham County Jail. With that in mind, Judge, I thank you very much for your patience. I have nothing else to add if you have no questions.
I do not, thank you. And Ms. Chartier?
Thank you, Your Honor. As this court well knows, punishment does not just mean incarceration. Mrs. Klages has 2 convictions now on her record, a felony and a misdemeanor that will be there forever. She has been convicted of lying to a police officer and is forever linked with the horrific actions of a man who caused turmoil and devastation to so many. It is not a scare tactic to talk about COVID-19. Mrs. Klages has multiple risk factors, including her age. What we know about COVID-19 is that it can kill anyone at any time. The first woman to die from COVID-19 in federal custody was a 30-year-old woman. The jail had the COVID-19 outbreak started by a female vendor who worked in the kitchen. The jail had gotten clearance and said that they were complying with all MDOC procedures, yet still there was an outbreak of COVID-19 in the jail. It's not the fault of the jail that a global pandemic has crossed its barriers. It's an indication of the threat of this devastating and deadly virus. What we know, not from the media, but from the American Medical Association, is that individuals in custody are 3.3 times more likely to die from COVID-19 and 5.5 more times to contract COVID-19. That's from June of 2020. At a bar here in East Lansing, there were 0 cases of COVID-19 until there became 185. At a local warehouse, there were 0 cases of COVID-19 until there were 46. We see this over and over again. Right now, there are 0 cases in this courtroom until, unfortunately, someone gets sick. It's not that no female at the jail has contracted COVID-19. It's just a matter of when it will happen. And is that the penalty for a 65-year-old woman who is a first-time offender with no history of violence? Coronavirus does not respect your person. You don't have to be elderly. It can strike anyone. A federal judge in New York said that realistically, and perhaps the only way to mitigate the damage in jails is to decrease the prison population and the population of individuals in custody. There's been a lot of talk here this morning about what if. What if Mrs. Klages had acted in 1997 based on a conversation that she genuinely does not remember? This court knows this, but it is worth mentioning in this courtroom that Mrs. Klages is not being sentenced based on what ifs. She's being sentenced on a purported lie in 2018. But the narrative that Mrs. Klages could have somehow stopped the devastation wrought by Larry Nassar is a false narrative to anyone who truly knows the facts of this case. We put just a small portion in our sentencing memorandum of all the individuals who were aware of the procedure and did absolutely nothing. And this came from documents from the Attorney General's office. This isn't a scare tactic or something we pulled from the media. We got it from them. Parents knew exactly what the procedure was, some of them did, and still consented to it for their children. A parent who was a paramedic, a parent who was a police officer, individuals not just at Michigan State University, but at other schools and around the country, athletic trainers, physical therapists, medical personnel, other coaches. They knew about this and they believed it was a legitimate medical procedure. Nurses, athletic trainers, psychologists, doctors, high school counselors were told and they believed that it was a legitimate medical procedure. More importantly, the police were told more than once, and they believed it was a legitimate medical procedure. The prosecutor's office was told, and they believed it was a legitimate medical procedure. So to try to put the devastation on this woman is false based on every fact that we know. It ignores reality. The government wants to tax Mrs. Klages for going to trial and asserting her innocence, and they should not be allowed to do that. She knew she would be subject to cross-examination by the government when she took the stand. She wanted to get up there and say she genuinely did not remember. She didn't have a brand to protect. In 2018, she was no longer employed by Michigan State University. She owed them no loyalty whatsoever. When the allegations against her came out in 2017, she never spoke publicly about them. If she was trying to protect her brand, the university's image, she would have publicly stated what she said in this courtroom here today. Not once did she ever publicly criticize the women who said that that conversation occurred in 1997. And she took great pains when she spoke to the agents to say she just did not remember. The government's criticism of the polygraphs is again false, because Agent Dwyer is himself a polygraph operator. The Attorney General's office uses polygraphs. We did that as a mechanism to try and show you that she doesn't remember. How are we supposed to prove a negative? We tried to do it in the best way that we could. The government has repeatedly said the jury has spoken, and we understand that, and we respect that. But we also know that jury verdicts are not infallible. The National Registry of Exonerations was formed in 1989. Since that time, there have been 2,645 exonerations. We know that. We've contributed to that list. It's not just someone being found not guilty. It is actually proving someone innocent. That is 23,500 years that have been lost when a jury found someone guilty, when the government didn't believe they were innocent, when the police didn't believe they were innocent, when multiple judges didn't believe they were innocent. We respect the process, but to put a jury verdict out as infallible, again, ignores what we know in working in the criminal justice system. There have been critiques made to the defense of Mrs. Klages. And respectfully, I think that's one of the most dangerous narratives I've heard in the courtroom here today. Criticizing our representation of Mrs. Klages because we vigorously questioned witnesses during trial. Our oath as attorneys is that we must adhere to the Constitution of the United States and the Constitution of the state of Michigan. We all took the same oath, but our requirement as criminal defense attorneys is different. It requires that we zealously represent our client. That constitutional mandate doesn't change because the government thinks that we shouldn't be aggressive, or because the witnesses are nice people, or truly victims, or mothers, or kind, or religious. Our oath and our constitutional duties certainly don't change because we have an unpopular client. In fact, it's even more important that we hold true to our duties when our client is unpopular. When everyone has turned against her, the government, the media, the public, we're the ones who stand by her. And we're proud to stand by Mrs. Klages. I speak for every single member of our law firm. Our nation's founders believed that our job was so important that they enshrined it in the Constitution. In every courtroom, in every state, in this nation, it's criminal defense attorneys who hold the government accountable. Without defense attorneys, there is no rule of law. But you wouldn't know that because we're critiqued for doing our jobs and questioning witnesses. There must be questioning of witnesses who make accusations. It can't happen the way the government wants, where someone makes a claim and there's no investigation and no cross-examination. It's not unique to this case. Cross-examination is the fuel and the engines of trials nationwide. We stand with Mrs. Klages because of our Constitution, but we also stand with her because we're proud to do so and we're not alone. Mrs. Klages has tremendous support. There were roughly 200 letters submitted on her behalf. And we actually didn't submit all the ones we received because the volume just got too great. These are people who know her, not just family members and friends, but gymnasts, MSU gymnasts, some of whom were survivors of Larry Nassar, who are standing by Mrs. Klages. They know who she truly is, a kind, genuine, caring person of high character. This court is aware, because the government made it aware, that Mrs. Klages turned down an offer. She did so because she refused to come into court and even accept a no contest plea because she did not remember and does not remember that conversation. As I said to the court, she went to a therapist in 1997 to try and remember. This was before she'd ever spoken to the ages. She had no reason to do so other than she was being accused of having behaved this way. She couldn't remember and wanted to remember. We know that no one involved in this case will ever be the same. The pain voiced by these two women is real and genuine. The lives of those who have been assaulted have been irreparably changed. While there is so much devastation that has occurred, I think these women and others who have spoken up are the voice of change. They may save devastation from occurring to other women who they will never meet. Others who would have been victimized in the future may never know the pain of assault because of the actions that have occurred. But to blame Mrs. Klages for devastation that she has not been convicted of is not appropriate in this case. The probation department has come up with a sentence that serves the ends of justice. We ask the court to consider that and to sentence Mrs. Klages accordingly. And Mrs. Klages has some words that she would like to speak today.
Of course, Ms. Klages.
Your Honor, I cannot express how much sorrow I feel for Miss Boyce and Miss Fountain and the numerous other women and girls and their families who have been affected by Larry Nassar's actions. I understand that the jury reached a verdict, and I understand I'll be sentenced on that verdict, and I accept that. But I want you to know that I truly do not remember the conversation that Miss Boyce and Miss Fountain say occurred in 1997. If it did occur, and I responded the way they said I did, I'm truly horrified, and I'm so sorry. But I can't imagine that I would not take seriously the concerns raised if they were expressed to me in the way the women remember the conversation. I've had many MSU gymnasts come to me over the years with all kinds of issues: sexual assault, abusive relationships, eating disorders, mental health issues, and more. And I always tried to get them the help that they needed. Even when I did not know what to do, I always talked to someone to make sure that they had the counseling and resources that were available. I've always prided myself on trying to keep and protect my gymnasts at all costs, which is another reason why I've struggled with the claims made against me. The thought that I may have ignored young women who were hurting and in pain and needed help at times has been unbearable. Through the legal process, I have learned that Larry Nassar victimized members of my MSU gymnastics team. Women that I dearly love were his victims. I sent my only daughter, Raven, to see him for a back issue in 2003. Both of my sons, Matt and Dylan, went to see him for various injuries. And at least one man has come forward who was abused by Mr. Nassar. I sent my granddaughter, Lily, to see him in 2010. There was no hesitation, no doubt at all on my part to send my loved ones to him. I trusted him. I thought he was one of the most intelligent, caring, and kind doctors that I'd ever dealt with. I was obviously very wrong. He had me completely fooled. I exposed my children and granddaughter to this man, and I never once thought that they were being exposed to a predatory monster. I racked my brain trying to remember the conversation that they say occurred when the allegations first came out in 2017. I asked people in my life at the time, fellow coaches, assistant coaches, athletic trainers, family members, and everyone I could think of, if I ever mentioned this conversation or anything similar to them. They all said no. I tried to remember if I ever spoke with Larry Nassar about this, and I still don't remember ever speaking to him about it. But I wondered if I did make that call, did he convince me it was a legitimate procedure as he did so many other professionals? And that's why it's something that I don't remember. In 2017, after the allegations came out, but before I was charged, I went to see a therapist to try and remember this conversation. Even though I can't imagine that I would ever respond the way that they said I did, I still struggle with guilt and remorse. And I know it does not compare with the experiences of the survivors. Sometimes the weight of it all has been crushing to me, and it still impacts me every day. Even when I don't express it to others, I struggle with what I've been accused of and what my role in this tragedy may have been. I continue to see a therapist to deal with all of this. I know that my experience going through this process is nothing compared to what so many women have gone through. The harm and devastation cannot truly be understood. And I want to say clearly that I'm so sorry if I had anything to do with it.
Thank you. Well, first of all, I, again, have read the letters on both sides that were submitted. I've lost count how many for the prosecution, and then 100 or more submitted on behalf of the defendant. And I acknowledge those letters. I acknowledge that the letters submitted for the prosecution are filled with pain and suffering at the hands of Larry Nassar. And the pain and suffering that they expressed, they felt from Ms. Klages not protecting gymnasts or reporting what was occurring as they've described in the letters. I also acknowledge the letters on behalf of Ms. Klages that describe a person believed to be of good character who has loved others as much as she has loved. And all of those letters on both sides are important and valuable to the court. I have to say something here about attorneys. I do not fault for one moment a crime victim who comes to court, goes through a trial, and feels hurt and angry over the process of being cross-examined. Some trials they're flat out told they're liars, others they have bad memories, whatever the case may be. I do not fault that. But I have to say something in the public interest so that Ms. Chartier is not the lone voice speaking out on this today. So it is commendable that RF and Larissa Boyce came forward and told what happened. It is equally commendable that two really fine public servants like Ms. Hageman-Clark and Mr. Rolston and the investigators listened, heard them, and acted, and represented the interests of the people at trial to bring about justice. It is equally commendable that a fine defense team like Mr. Niamfakudza, Ms. Chartier, and Mr. Krause would represent Ms. Klages. And I know people don't like to hear that. It is the truth. We would not be here today if it weren't for all of the attorneys involved in this case. We would not have justice today if it weren't for all of the attorneys involved in this case. If they sat there and made a weak cross-examination and did not vigorously, zealously defend their client, we might be here today, but the case would get reversed by the Court of Appeals for ineffective assistance of counsel. I have seen a lot of trials. I've seen an elderly woman who knew the defendant all of her life, who knocked on her door, pushed his way in, and forcibly raped her, get called a liar about the entire incident, including who did it. It's painful sometimes, and I understand that. But that is absolutely necessary to our system of criminal justice. And I applaud the attorneys on both sides, prosecution and defense, for making this system work. Now, I've also considered the defendant's sentencing memorandum and the remarks that have been made here today. The sentencing memorandum, as we've already noted, are replete with two arguments, as well as what's been said here today, two arguments that I want to address. Specifically, the defense has argued that the defendant is not in need of discipline or reformation for two reasons. And basically, I've boiled them down to this. One, she cared about her gymnasts and would never expose them to harm, and in fact sent her own family to Larry Nassar. And then the second argument is that parents, paramedics, police officers, physical therapists, athletic trainers, etc. were either in the room during an assaultive exam or knew about the assaultive exams and also did nothing. These arguments are mostly irrelevant at sentencing today because we're here not for Ms. Klages sending gymnasts to Larry Nassar or even for failing to report Ms. Boyce and RF's complaints. The sentencing convictions are for lying to the police in 2018, a crime that the jury found Ms. Klages intentionally committed. But I still have to comment briefly on those arguments because it's taken up so much of the arguments that have been made, again, in the sentencing memorandum and here today, and also in the letters of support. The sentencing memorandum says that those two arguments are the reasons why the defendant is not in need of discipline or reformation. My comment in brief, again, is that's not the point. Everyone across the board calls Larry Nassar a master manipulator, and I think we can take that as true. I wholeheartedly agree with that. I've actually had the unfortunate responsibility to view an assault that Larry Nassar made on a young woman that was also video recorded. And knowing what I know now, it was beyond disgusting and sickening. But had I been watching it 20 years ago, I'm not so sure. He gave a very convincing impersonation of a doctor. Likewise, the people who watched these exams or knew about them but did nothing were fooled by the same master manipulator that anyone could have been fooled by if they had watched or heard about this back when it was taking place. But Ms. Boyce and RF were not fooled. Others weren't also, but I'm addressing Ms. Boyce and RF because they're the victims of this crime being sentenced on today. And part of the reason they weren't fooled is because they weren't observers of the assault. They weren't people who were having the assault described to them. They experienced it firsthand. They lived it. They felt it. They knew. And unlike the police, athletic trainers, parents, physical therapists, and all the other people that Larry Nassar fooled, Ms. Boyce and RF were minors under the care and supervision of Kathy Klages, and they reported the assaults that they firsthand experienced to her. And again, I might add that although it's not the crime for which the defendant is being sentenced today, the jury had to have found that Ms. Boyce and RF did report the assaults to Kathy Klages in order to have found that she lied to the police in 2018. So in summary, the reasons that the defendant posits for not being in need of discipline or reformation don't relate to the sentencing crime and just don't stand up to scrutiny. That said, what is the appropriate sentence that takes into account discipline, reformation, deterrence of others, and protection of society? I've considered not only Ms. Klages individually, and I have, but I've also assessed the types of sentences I've imposed on other offenders for the same type of offense. And rarely, if ever in my memory, is any jail sentence imposed for this nonviolent offense. However, in other cases, lying to the police has had really one area of impact, and that's been to temporarily, and in some cases very temporarily, thwart a police investigation. Here, it not only thwarted an investigation, but it also impacted 2 victims of sexual assault. And that emotional impact is far greater and far more serious than thwarting of a police investigation. Another factor that I'd like to mention is deterrence of others. Very little mention's been made of that today. The defense has made little mention of that factor, which I think is very important here. Sexual assault is one of the most serious crimes there is. The emotional impact on victims goes far beyond that of most other crimes. It impacts every aspect of their life, from the most intimate relationships they have to their public and working relationships. And when the police investigate sexual assaults, they are performing some of their most complicated and sensitive work. People should tell the truth. And when they don't, the impact on victims can be, and is, we see it all the time, confusion, self-blame, self-doubt, embarrassment, ridicule, and on and on. And there's an even bigger impact, and that is the impact on society, which can be the perpetration of sexual abuse. Again, I acknowledge and I appreciate and I don't disparage the testimonials of Ms. Klagis's good character, but one of the legitimate purposes of a criminal sentence is deterrence of others, and that is a factor here. Now finally, the defendant also argues that the COVID pandemic is another reason why incarceration should not be imposed. Had I done this sentencing back about 4 months ago, I would probably take that and act accordingly. But since then, the jail has taken significant steps toward ensuring a safe and healthy environment. I will not send anyone to the jail if I think they're not safe and they won't be healthy. Of course, we can never guarantee anything, but I do not wish harm on anyone that I sentence to the jail. There is a protocol in place. It's an extensive protocol in place that the jail has put in place and implemented, and they've been practicing under it. And I won't reiterate it all here. It's been described by Major Southworth. It's been described in a number of operational memos that have gone through the jail from Major Southworth. And in particular, the one from Major Southworth, the email, Mr. Rolston, as he's acknowledged, has forwarded that to defense counsel. I am satisfied that while there's never any guarantees, there aren't guarantees even if you stay in your own home, I'm satisfied that the jail is a safe and healthy place for inmates to the extent that it can be. So for all of those reasons, my sentence is as follows. Ms. Klagis will be placed on probation for a period of 18 months, 90 days in the Ingham County Jail with credit for 1 day served. You have to pay $130 to the Crime Victims Fund, $136 in state costs, oversight fees in the amount of $540 payable at the rate of $30 a month, costs in the amount of $500 based on the State Court Administrative Office calculated average cost of a criminal case in Ingham County. Additional conditions of probation are no use or possession of alcoholic beverages, controlled substances, drug paraphernalia, or medical marijuana. Comply with both alcohol and drug testing if the agent in his or her discretion sees fit. You must use prescription drugs only as prescribed for you by a licensed physician. You must complete a substance abuse assessment if you are referred by your agent. You must complete outpatient or residential substance abuse treatment if that is deemed necessary. You must waive confidentiality and allow any program you're required to attend to disclose information about you to your agent. You must perform 200 hours of community service as directed by your agent. You may not have any contact with anyone you know to have a felony record. You may not possess a weapon while you're on probation. You must comply with all the written and verbal orders of your agent, allow the agent into your home at any time, submit to a search of your person or property without need of a warrant, Report any changes to your agent within 24 hours. Of course, this is a standard condition, but no contact whatsoever with RF or Larissa Boyce. And following the incarceration, 90 days on home confinement tether, and no early release on sentinel tether while incarcerated. Ms. Klages, you have the right to appeal your conviction and your sentence in this matter. You're entitled to an attorney at public expense to assist you in doing that. If you're making a request for one, you have to make it within 42 days of today's date. We're going to hand you a form that tells more about that and that you'll use.
I've received it, Your Honor, and I'll share it with Mrs. Klages. May I ask one amendment for not associating with anyone who has a felony record? Can there be an exception for family members?
Yes.
Okay, thank you.
All right, and if there's nothing further, then you're remanded to the custody of the sheriff.
One moment, Your Honor. I believe Mr. Kraus has one matter, Your Honor.
Mr. Kraus?
Yes.
Thanks. Thank you, Your Honor. I think we'd be remiss, despite the court's very clear and statements on the sentence, to not at least ask the court to consider a motion for stay. Now, there are two bases that I have for making this motion, Your Honor, and one of them, of course, is the COVID-19, and I don't want to belabor that more than has already been discussed, particularly by Ms. Chartier, but as well as the court. There's a second reason, and that has to do with the factors set forth in People versus Giacalone. But I do want to comment a little bit on the COVID-19, Your Honor. And first of all, I appreciate that the Ingham County Jail may well have protocols in place, but I would respectfully submit, and certainly with due respect to the Ingham County Jail, that's really not all that relevant. There simply can be no dispute that COVID-19 presents a serious threat in the carceral setting, particularly to individuals over the age of 60. Per the Centers for Disease Control and Prevention, as a 65-year-old, Mrs. Klages is at a higher risk for getting very sick from this illness. And I would note, I think the stay would be appropriate given the positive test that occurred in the jail during that outbreak in June, when there were 8 inmates and 1 civilian that contracted the disease. Whether any women have yet contracted the disease in the Ingham County Jail is simply irrelevant. That is not and cannot be the determinative factor here. Any idea right now that Michigan is currently flattening the epidemiological curve is completely shattered by Governor Whitmer's July 29th executive order, which is 2020-160, in which she expressly stated, "Our progress in suppressing the disease has stalled, appears to have stalled. Cases have risen over the past month from a rolling 7-day average of 354 cases per day on June 30th to 692 cases on July 28th, a twofold increase. Additionally, there were 426 new cases just on this past Sunday. July had the second highest cases in a month since the pandemic began. There really are only 2 facts that we know with any real certainty about COVID-19, Your Honor. One is that it continues to evolve and to present serious health challenges. And 2, the other fact that we know is that it is an indiscriminate killer and poses a tremendous threat to people in the carceral setting. And I would just add to that, Your Honor, that threat extends far beyond the prisoners and the facilities themselves. It's a danger to the public health. That is, the families and the communities that surround prison guards, nurses, and other staff. Because of how quickly COVID-19 spreads in jails, facilities with 0 cases can become hotspots, deadly hotspots, within a matter of days. So an outbreak would overwhelm not only, and again, due respect to the Ingham County Jail, but the relatively primitive healthcare system, but also the nearest hospitals if there's an outbreak. So with that, Your Honor, the court shouldn't consider not just Mrs. Klagis's health, but the public health in any certain sentence, during these extraordinary times, obviously for a nonviolent offender who represents no threat to the community. And to that point, Your Honor, the Michigan Supreme Court has issued Administrative Order number 2020-1, which strongly urged trial courts to take into, and I quote, careful consideration public health factors arising out of the present state of this emergency in making these kinds of decisions. The Supreme Court's order also states that during this state of an emergency, and I quote again, trial courts should be mindful that taking reasonable steps to protect the public is more important than strict adherence to normal operating procedures or time guideline standards. That order is still in effect, Your Honor, and it was issued in April, as is still in effect Governor Whitmer's Executive Order 2020-62, and albeit with respect to the early release of prisoners, stated trial courts are strongly urged to consider early release for older people. And finally, on this issue, Your Honor, in People v. Barber, on May 13th, 2020, the Supreme Court, Michigan Supreme Court, indicated that when trial courts are deciding whether to sentence someone or release them from jail, they must give significant weight to protecting the public health from the risk posed by the pandemic. The Supreme Court cited to its language in Administrative Order 2020-1 and found that the trial court in that case abused its discretion and clearly erred in its factual determinations regarding the public health emergency. The court stated, contrary to the trial court's statements, there are many indications that incarcerated individuals are at a greater risk of COVID-19 infection. And I appreciate the court's comments about 4 months ago. But the fact of the matter is, Your Honor, the cases are on the rise again. We haven't defeated this disease. We're far from it. The public health data is clear on that. The state's chief medical executive and the governor are all clear on that. So with respect to the pandemic and the COVID-19, there simply is no dispute that Mrs. Klagis's health will be put at serious risk by any term of incarceration. With that, Your Honor, I'd like to move to my second reason for granting a stay of the sentence, and that is that as a nonviolent offender, Mrs. Klagis is entitled to a stay because she meets all the factors set forth in People v. Giacalone. That's at 16 Mishap 352, and the pin site is 355 through pages 357. I'm sure the court's well aware of this case from 1969. But Mrs. Klagis has deep and long-standing ties to the community. She has already demonstrated that she will appear and has appeared at all times required by the trial court and is not a risk to flee. She poses no risk to the community, and there are significant issues of merit, both legal and factual, in her appeal. And there simply is no risk to the administration of justice posed by Mrs. Klagis remaining free on bond pending her appeal. If Mrs. Klagis is not granted a stay, I would also add, Your Honor, that she'll suffer irreparable harm. If the execution of her sentence is not stayed, she will likely serve all of this jail time, in fact, almost certainly will, before there is a final disposition of the appeal. And I would just add here, Your Honor, the government cannot deny that Mrs. Klagis they cannot deny her ties to the community, cannot deny that Mrs. Klagis has already demonstrated she will appear and has appeared at all times required by the court, that she's not a flight risk, that she certainly poses no potential for harm or violence to the community, and that she would be no risk to the administration of justice by her remaining free pending the appeal. Submit that if she is incarcerated, obviously after any necessary motions, full briefing, hearings, decisions, the critical issue of whether a jail sentence should have been served will have been rendered moot. So, Your Honor, under the Supreme Court's order in Barber, I would ask that you do consider Mrs. Klagis's age, the attendant danger COVID-19 poses for her, and the risk to the public health not just that of Mrs. Clayton. Again, she satisfies all the Giacalone factors, and I would ask that, with due respect, the court grant a motion for stay of the sentence pending the appeal.
Thank you. Are the people wanting to be heard?
Sure, Judge.
Okay, then why don't you all have a seat?
Thank you, Your Honor.
It'll just take me a couple seconds, Judge. I agree with Mr. Krause, Giacalone controls. I agree 3 out of the 4 factors. I'll stipulate, she's not a threat to the community, not a threat to flee. But really the issue, it was not touched upon by Mr. Krause, and maybe he will in a moment here, but the substantiality of the grounds of appeal. The most common place for appellate issues is jury instructions. And going back to February, I don't think there was any contention over what jury instructions the jury was given. So in terms of that being an avenue for appellate error, I don't see that. The substantiality of the grounds of appeal are rather lacking. That factor is missing from the Giacalone analysis. With that in mind, what I'd say is, one of the things that Giacalone did talk about a little bit is, the community's perception or the harm to the community of delay of sentence. And by delay of sentence, the, justice delayed is justice denied. This has been a matter, obviously, going factually back to 1997. The community, and I'll echo the court's sentiments. I agree that deterrence is really important in this case. I hope the people at the University of Michigan, at Stanford, at NYU, and every university in between is paying attention to their obligations as university administrators to tell the truth, even if it's hard. The finality of the sentence, obviously, I agree with Mr. Krause. I mean, she'll serve 90 of it in the 90 days before the Court of Appeals will reach its decision. But the substantial, there's no huge issue here. There's no cornerstone groveling issue that the Court of Appeals is likely to reverse this case. So with that in mind, Judge, I'd ask the court to impose sentence forthwith. Any questions?
No, thank you.
Thank you.
I'll just give Mr. Krause a chance for rebuttal.
Thank you, Your Honor. Very briefly, obviously I disagree rather strongly with Mr. Ralston on the issue of whether or not there's substantiality on the grounds of appeal here. I'm not going to re-argue all the motions that we filed before this court and this court heard and decided, but there are a number of issues on appeal, all of which I would submit, again, respectfully, are very substantial, including certainly not least the court's decision to not allow Dr. Loftus to testify. There are constitutional issues here that we raised in our motion to quash, as well as the other issues raised in that motion with respect to the elements of the crimes charged and whether or not the government met its burden of proof. And I would just note, I think it's important too, that the Eaton County Circuit Court had a different view of many of the same issues that were prevalent or present in the case against Dr. Simon. And in fact, granted the motion to quash in that case. That, as I understand it, has been appealed by the Attorney General's office. Obviously, this case is going to be appealed. But point being that that court had a different view of many of the same issues that were involved in this case. So I think there's very much substantial grounds for appeal here. So if that's a factor that the court needs to look at in determining whether or not we've satisfied the Giacalone factors, I would submit that we have, Your Honor.
All right, thank you.
Thank you.
Well, the people agree, the court agrees, there's no threat to the community here, there's no fear of flight, and the issue is substantiality of grounds for appeal. But let me back up first and do the first one, the COVID argument. Again, for all the reasons that I previously stated, I'm not convinced that there should be a stay because of the COVID issue. I did look at the order from the governor that recommended courts considering early release for certain age group. I hesitate to say elderly since I am of the same age. But to consider early release, and I concluded that it was a suggestion. It was a suggestion that I did contemplate in formulating a sentence, and I decided that the need for punishment and deterrence of others would only be served if there was some initial incarceration. And the suggestion in the order to consider early release is addressing people who have already had some impact of incarceration and should be considered for early release. And I just didn't see that as applying to Ms. Klages. Also, I don't think that people incarcerated are necessarily at a higher risk of getting COVID. I understand the risk of spread if it's introduced into a jail. And it's something I considered very carefully. But she's not, because of her age, at a higher risk of getting it. She's at a higher risk of suffering very more dire consequences at her age. I am satisfied still that the jail is taking extensive measures to protect against that. And I would note that I believe when they had their outbreak before, they had not yet instituted all of the measures that they have now. For example, when they had the outbreak before, they were holding people that they could not send to the Michigan Department of Corrections because of the fear of, taking it from the jail and sending it to the Department of Corrections. Since then, they have established such stringent protocols that they've actually approved to transfer prisoners from the jail to the Department of Corrections. So the people that I sentenced that were sitting there waiting finally were released and sent on because of the protocol. So things have changed. Not just because of the levels of the virus 4 months ago, but by the measures and the steps that the jail has taken since then, and the greater awareness and the greater seriousness that everybody's taking over it. I acknowledge the numbers still today aren't great. They're very worrisome. But I still maintain that the jail is handling it. And while I understand the fear that if there is COVID introduced into the jail, the outbreak consequences could be dire. They actually did have an outbreak, and it did not overwhelm the jail. That's not to minimize the health risk that placed on inmates. But the point is that even back when they were less protected than they are now, the jail managed it and managed it very efficiently. So I just have to reject all the arguments about COVID. And that takes us to the factors to consider for a stay, and the one that's in dispute is substantiality of the grounds of appeal. And I do recall the numerous pretrial motions, and with all due respect to defense counsel, I think that those issues regarding Elizabeth Loftus and the one involving the elements of the crime just didn't have that much merit. There was much binding authority regarding the Elizabeth Loftus issue that I don't think is an issue. And the facts of this case, as I outlined when I ruled on that, the other evidence that was available, it just did not scream out any kind of a big issue with regard to an expert on memory. And then there was the elements motion, and again, I think that if someone just made a cursory review of the case that I think was unpublished, but I could be wrong about that, I think it was unpublished. If someone just made a cursory review of that, they might say, yes, the defendant was dead bang on the spot. But delving a little bit deeper into it, I really think that I distinguished it and distinguished it correctly from what we have here. And then finally, the Eaton County case, well, you know, I don't know on what grounds the judge dismissed those charges, I really don't. But all judges in the exercise of their discretion can disagree. And I still think that the case here is sound, strong. I think the trial was fair. I don't see a substantial issue on appeal. I know there will be issues raised, and again, fair and required and understandable, but I don't see substantiality of grounds for appeal. I'm denying the stay.
I have an order.
Okay,
May I approach council briefly?
Yes.
May I approach, Your Honor?
yes.
Thank you, Your Honor.
Thank you. And that will conclude our hearing.
Email me.
Absolutely.
Thank you.
Will do.